now. So we are now recording. And Jonathan and Norm, thanks very much for agreeing to do this. Just, for background, and I think, Jonathan, you know a little bit about it, but Norm, so we formed an affinity group about a year ago at the synagogue called LawyeRS, try to use the acronym. Mm-hmm. So far we've put on, a couple of terrific programs in the spring. In fact, speaking of Clarence Thomas, we had one of our congregants argued the case where Thomas broke his however many years of silence.
Oh, yeah.
Ask her a question. So she got to talk about that. And we had another congregant who argued, this Ron Castile case having to do with conflict of interest from when he was both a justice and the attorney general, which was great. And then we had somebody who clerked for Justice Ginsburg talk about that experience. We did a program down at the Constitution Center as well. So we've done, a bunch of different things, and we're trying to use this time to try to stay connected. We're kind of doing a check-in next week. We're doing a little chat on the Federalist Papers and the scope of executive power, which is, of course, certainly in the news right now, next week as well. And we did a program, I want to say 2 weeks ago, on, again, one of the COVID issues where we had one of our congregants talk a little bit about the labor issues and issues about family and medical leave and all some of the new legislation that's been passed, over the last month or so.
Right.
So just as a background. So maybe I can turn it over to you guys to sort of introduce the topic and yourselves, and we can get started.
Great. I'm going to try to share the screen here. And if it works, you should see some slides.
We do.
Some slides, great.
Well done, Professor Lipson.
Professor Powell. So I'm Jonathan Lipson, and with me is Norm Powell. I think everybody knows everybody else pretty much. And what we wanted to talk about today was a model of standstill tolling agreement that we published with the American Bar Association. It's about 3 weeks ago, 4 weeks ago, Norm?
Yeah, just about 3 weeks.
And so this is really our first time presenting it. We've been asked to present this to a number of different audiences, and you guys are sort of the beta test. So we'll be interested in hearing your feedback on it. We think it's mostly pretty straightforward stuff. I think there is a disclaimer that you probably don't need because you're all lawyers, but obviously this is not legal advice. We're not performing legal services. We're not your lawyers, et cetera, et cetera. So Norm, do you want to get started? Do you want me to do this?
Yeah. So why don't you take? You start off with the odd, and I'll take the even, and we'll just sort of go from there.
Perfect.
Okay.
So the reason we did this, we developed this model, is because it occurred to us, I don't know, about a month ago or so, that given the way things were going, all or almost all contracts were likely to be in breach sometime in the near future. And that was a problem. And it was a problem both for the parties, and at least initially it occurred to me it would be a problem for courts, because either people were going to be running into, courts of general jurisdiction and suing on the breach, or they were going to be running into bankruptcy court to try to stay that litigation. And in either case, we thought, well, there may be a better way, some alternative to litigation. And so the solution that we've come up with is certainly not the only one that one could imagine, but the solution we've come up with is one that's, I think, probably familiar to most lawyers, and that is the model standstill tolling agreement that we'll talk about. And I should note at the outset that it's a very basic agreement. It's aimed really at folks who can't afford you guys. It's for small and medium-sized businesses that might want to enter into some kind of alternative arrangement while they're figuring out what they're doing, but perhaps either don't have the resources to pay for counsel, or perhaps want to use what resources they do have for something else. So it's a very basic agreement in many respects. If it's, we hope it's of use to anybody who looks at it, but it's especially targeted at small and medium-sized enterprises.
So who are we? Well, you of course know Jonathan, and I'm pleased to say that I've worked with Jonathan professionally for probably 2 decades now. And he's, as usual, rather modest. He reached out to me in early April with this idea that, you know, maybe it would be helpful to facilitate people's just calling a timeout, if you will. Our thinking behind this initiative was there's probably on the part of many people who find themselves in defaulted contracts or soon to default contracts, a tendency to move toward action, to do something, to exercise remedies, to go to court, to try and compel performance. And our thinking was that, as Jonathan said, that might not be the right thing right about now. Why? A lot of reasons. The courts themselves are working remotely. Delay that we all know attends litigation may be further exacerbated. Litigating costs money. Part of the reason we anticipate this situation being such a problem is people won't have a lot of spare money, particularly not the target audience here. So one of the fundamental objectives here is to encourage people to just sort of stop and think and consider that a course of action other than that which intuitively comes to them might in fact be in their best interest. It's difficult to reorganize things as between contracting parties in an optimal way for a future that we still can't see. So hence the idea of, you know, don't just do something, stand there. As you know, Jonathan Lipson teaches at Temple Law School. I practice at Young Conaway in Wilmington, Delaware. We're both members of the American Law Institute, the American College of Commercial Finance Lawyers, and both officers of the American Bar Association's Business Law section. As usual, Jonathan's a couple of paces ahead of me. He is the former content officer for the Business Law section. I'm the incumbent content officer. I will in time follow him into former content officer land. This is certainly not our first collaboration, and it certainly won't be our last, but it is, as all of them have been, something that I think is very worthwhile. And we've really had a lot of great press on this across the country. There seem to be a number of folks that are really picking up on this as something that might help to generate thinking in what we consider a positive direction. John, you want to talk about our roadmap?
Sure. So actually, before we get to the roadmap, Norm is also being characteristically modest. He is an adjunct for us at Temple. I've only done really 2 intelligent things in the last several years. One was I got Norm to agree to teach the UCC Article 9 course for us, which he does, I think, better than anyone in history. And number 2, I got him to agree to be my successor as the content officer for the business law section, and thus my success in that position. The roadmap is pretty straightforward, right? We're going to spend a few minutes talking about the problem. COVID-19 has produced the potential for really massive breaches of contract, which we expect will result in one or both of 2 responses. In many cases, we think business people will simply be in denial. I mean, there's some sort of behavioral aversion to dealing with problems that you find overwhelming, and we expect that to be the case here. Alternatively, or in addition, we expect dispute. So, at some point things will become so bad that people will litigate. Obviously, many people already are litigating. We'll talk about that as part of the problem, because we have plenty of examples of folks who have not entered into standstill tolling agreements. But most of what we want to talk about are the kind of key features of the solution that we've cooked up, which is this standstill tolling agreement. So, you want to talk about the breach?
Yeah. So, what sort of breaches are we focused on here? Well, what you'll see as we get deeper into the slide, sort of the back half is a walk through the annotated model form that we've published. And nomenclaturally, we use the terms debtor and creditor. That's just a drafting convenience. It could be anything, of course. Sometimes it's someone who owes a monetary payment and doesn't make it. Sometimes it's someone who's obliged to deliver widgets and can't. Whatever it is, right? It's an obligation that's just not quite being lived up to. We're anticipating that we're going to see a fair number of payment defaults. We're going to see, of course, a cascade into various covenant defaults, you know, the usual things we see in our loan facility documentation, production or delivery delays, inabilities, what have you. There will certainly be some folks who are parties to contracts that simply cannot be performed at present because they, you know, literally can't do what they are supposed to do because they're under executive orders to not do it. And we'll come back to that concept because there are other things afoot where people are doing things that are arguably necessary for their doing the things they're contractually bound to do, like earn money in order to make payments. And so we'll talk a little bit about, you know, some of the challenges hinted at by the last bullet point here, material adverse event. You know, we talked a little bit about whether we should include in this talk force majeure, you know, back, things like that. And, you know, my sort of pithy, not necessarily helpful response is, well, it all depends what words they chose to you know, to comprise the provision, the contractual provision at issue. You know, they say what they say, neither more nor less. But that's a very shorthand way of saying it isn't that easy to simply waive a so-called boilerplate provision that perhaps not a lot of context-specific thought was put into at a time like this, which I dare say is a time that was not consciously on the minds of draftsmen of the various documents we anticipate are going to be in default. With that, John, force majeure?
Sure. And before we jump to that, the picture from the New York Times there is about the Victoria's Secret acquisition litigation. Some of you might have seen it. It's probably the highest profile example of the sort of problem that we've identified, which is, you know, folks who are, you know, about to sell a business or something might have clauses in their contracts that permit them to back out in the event that there's a material adverse event. Apparently that's the claim in Victoria's Secret. So, you know, the buyer is trying to walk away saying that, you know, nobody predicts the Spanish Inquisition, right? Nobody predicts coronavirus. And so, you know, that's ongoing. The response to those sorts of claims of breach, of course, will be to assert a host of defenses. And we're just going to whiffle through them quickly because, you know, the whole point for us is that you're likely to be better off in the first instance negotiating some sort of truce rather than litigating the fine points of these doctrines, which in many cases are, you know, a bit fuzzy. So the classic one that I think we think of when we think that there's been some act of God or some extraordinary event is force majeure. And this, you know, typically will refer to a clause in a negotiated agreement that says performance is excused under certain conditions. You know, number one, the claimed event of force majeure was truly beyond the party's control, not the result of the party's fault or negligence. Number two, the non-performing party tried their best to perform, but was unable to do so. And, you know, you should see, I'm sorry, I'm stepping on an even numbered slide, Norm, but
Good. It's all good.
We've got, you know, already in the last month, just a bunch of cases litigating what those words mean. So as Norm suggested before, you can put into the contract virtually any words that you want to try to excuse performance on force majeure grounds and think that you have adequately expressed the intentions of the parties. But when, you know what hits the fan, people may not necessarily think that the same words mean the same things or may not want them to. And so they may end up in court, which is the place that we think they should not be. Norm, you want to talk about impracticability?
Yeah, let me just back up for a moment and say a few words, though, about some of those cases, because they bring to mind some of the things that, you know, we all sort of roll our eyes and lament. In Pacific Collective, the first one mentioned, the term force majeure was actually defined, and there were 18 different catastrophes that were listed as comprising force majeure. They did not include things like pandemic or epidemic or contagion. And, you know, as we all know, the longer your list of the included, the greater the ammunition for the argument that it's an exhaustive list, not an illustrative list. Palm Springs, it was an action for rent due, and somebody said, well, we've got a force majeure that says neither party's excused from paying any monies owed. So questions like, well, yeah, but like, does that even mean rent? And that's kind of like the whole point. So there were a number of these instances where you're looking at some of the classic drafting, challenges we have. E2W, government mandated a shutdown of the amusement park, so the franchisee stopped paying the franchisor. The defense, of course, well, it was a government order. We had to shut down. Like, well, yeah, but you didn't have to stop paying us. So as Jonathan suggests, these things are ripe for plenty of protracted litigation, and that's probably not, in the interest certainly of the constituency that we were hoping to provide some relief through this exercise. On the next slide, to speak a little about impracticability. Yeah, so here there's really again a couple of tests, but essentially you've got this overarching notion that performance is possible. It can be done, but it's extremely impractical or infeasible, very difficult, very expensive, things of that nature. So number one, something must have happened which was assumed not to have occurred back when the contract was being entered into. The occurrence made certain performance exceptionally difficult or expensive, as I alluded to, and could not have been reasonably foreseen, right? And we're all lawyers on this call. I mean, can you reasonably foresee a pandemic? Well, yeah, they happen every 100 years or so, and we're, by some measures, we're overdue. Did you know it was going to happen now and that it was going to be COVID-19 as opposed to 18 or 23? Certainly not. So what do all of those, things mean in terms of this old, as Jonathan aptly put it, fuzzy doctrine? It becomes very difficult, time-consuming, and resource-consuming to litigate and figure that out. We do have some overlap with impossibility, which we cover a bit on slide 10. And when we turn to impossibility, we're talking about, well, literally, it's not possible to do what it is that the parties had intended. One of the examples I came across was, suppose you have a contract for a painter to paint a house, and the house literally burns down. There's nothing left. Well, it is impossible for the painter to perform that contract and paint that house. Contingency has occurred, right? Was not due to the negligence of either party. We got no arson here or anything like that, right? And rendered performance just infeasible. You can't paint a house that isn't there. So that would be our defense of impossibility. But that brings us up to a closer look at the doctrine of frustration of purpose. Jonathan?
Sure. And one of the things, you probably all know this, but these doctrines, impossibility, impracticability, frustration, are common law doctrines, or in the case of impracticability, embedded in the UCC 2615. And so there's no requirement that they have been drafted into the contract as you would presume with a force majeure clause. Force majeure can be a common law defense as well, but it's much more likely to be asserted based on the language of the contract. The ones we're talking about now are, things that people fall back on when they don't have language in the contract. And frustration of purpose is, I think, similar to impossibility and impracticability, although it tends to focus more on the difficulty of actually fulfilling the contract as opposed to the sort of background problem that arose. So number one, the frustrated purpose must have been the principal purpose, without which the contract wouldn't have made any sense. Number two, it must be substantial and not a risk that had been assumed by the parties. And number three, the non-occurrence of the frustration must have been a basis based on an assumption that was reasonably made at the time the contract was formed. As I say, I think these are all, there are obviously some subtle variations between the doctrines. I think they're all fairly fuzzy. I think they are certainly a playground for litigators, or can be a playground for litigators. And our sort of instinct was that's probably not the thing that is going to be best for most folks most of the time if they can avoid it.
And that really brings us to, right, as I said at the beginning, we were hoping that we might encourage people to think about things in a way that they otherwise might not. There's a natural inclination. Hey, you promised, you bound yourself contractually that you were going to do X and you haven't done it. That makes me angry. I have rights. I want to enforce those rights. And yet sometimes enforcing those rights is not economically rational, at least not at the present time. And so the threshold thought for this initiative was, whatever we know now, hopefully we'll know more sometime in the not too distant future. So maybe we all call a timeout. Instead of spending a lot of money, instead of spending a lot of time, instead of a lot of time being elapsed during the pendency of a litigation, without even getting into the odds of actually recovering anything that's awarded by way of judgment, right? Because if you can't get blood from the proverbial stone. And then of course, there's another dimension, there's relational damage. We also started from the premise that a lot of folks are in appropriate and otherwise good commercial and contractual relationships. And it may be very difficult at this point in time for one party to find a suitable replacement for his counterparty in a similar undertaking. This is not really a problem that is unique to a given actor. This is affecting the whole of our economic society. So we thought that rather than having all those expenditures, all that time lapsed, and all that damage to what may very well otherwise be a very promising and worthwhile of maintenance commercial relationship, just a little time out till maybe, hopefully, we can see a little further down the road with some measure of greater clarity and start to exercise rights at that point. So Jonathan, you may have some transitional thoughts to share, and then I think we're about to sort of walk through our annotated agreement.
No specific transitional thoughts, except that the thing that we're really talking about is a model form and an article that we wrote about it. The article and the forms appeared in an ABA publication, the Business Law Today. There's a link to it at the very front of the slides. I think you might have been provided with those materials before this. And the article, you know, summarizes what we're trying to accomplish. And then the contracts themselves are there for anyone to use. We created both an annotated version, which has some of the stuff that we'll be talking about over the next, 20 or 30 minutes, and an unannotated version with live boxes that parties can actually just complete and then execute. And so the idea is, we want to make it as easy for small and medium-sized enterprises to do this thing as it can possibly be. And so we don't know exactly how many folks have entered into it. We asked our friends on the ABA staff to let us know what the hit rate had been. And I think after, was it about a week or 10 days, there'd been about 3,000 hits.
Yeah, they exceeded 3,000 in the first 2 weeks, which was very good for Business Law Today, which is a sort of an electronic magazine, if you will, published by the Business Law section.
So that's the work product. And when we talk about the model, that's where the model is. And it starts out, like any sort of normal looking agreement. Because it is for small and medium-sized enterprises, we try to keep it as simple as possible, but at the same time balancing a desire, maybe the right one, maybe not, to make it look legalistic. If our expectation is that most users are not going to be lawyers, but they're going to be people who are trying to address a legal problem in some way outside of the legal system, we want it to look like it's a real legal document. We want them to take it seriously in the same way that they take any contract seriously. And so it has a preamble, which is of course what you see in front of you. And as you can see, what it does, among other things, is it has these little places where you can key in the sort of basic attributes of the agreement that you're trying to freeze. I'm sorry, this is where you key in the basics of this particular agreement and the parties to the underlying agreement that is being frozen. And we decided, again, in the spirit of making this look like it's you know, a real contract to add some recitals. Norm, you want to take us through
Yeah.
those?
So in addition to that reason specifically, we chose these recitals because we said, listen, if we're entering into a standstill agreement, and that's the term we used, again, they're just, you know, drafting mechanisms, but we wanted to be able to conveniently refer to the standstill agreement, what we're talking about and walking you through, and what we've called the underlying agreement, which may be, in fact, you know, several different writings, right? It could be a loan agreement and a promissory note and a security agreement, and what have you, or it may be a simple supply contract or what have you. But there's an underlying agreement. Our assumption is there's an underlying agreement that's not being performed in accordance with its terms, presumably, you know, to some extent caused by the COVID-19 situation. And so as you proceed through the whereas and recital provisions, there's a acknowledgement of that as sort of the background in which this is unfolding. And then again, nomenclaturally, we simply use the convenience of debtor and creditor. And then sort of, you know, in the last of those introductory clauses, this notion that they both sort of agree to avoid legal action for the time being. Just sort of call it a little timeout until perhaps they have greater clarity as to what would be appropriate objectives to seek and try and bring about.
One of the things that, you know, my students always ask me when we talk about recitals is, well, why do you have them if they're not really part of the operative agreement? And at least part of the explanation I give them is that it helps the parties kind of frame what they're trying to accomplish, so that it sort of sets, you know, some psychological boundaries around the goals. And that's in part what we've tried to set up here, that we're trying to remind the readers, you know, both, you know, why they're having problems and why they might be able to achieve at least an interim solution. You know, maybe it has that effect, maybe it doesn't, but it's as much behavioral, I guess, as it is intended to be legal. So the first thing, you know, that they would, substantive thing that they would get to, the first operative thing they would get to is scope. And, you know, it's what we're trying to do here is be clear that the standstill pertains only to the underlying agreement as it was previously defined. What we're, you know, trying to be careful about is not suggest that people are freezing rights or, you know, responsibilities with respect to other aspects of their relationship, other problems that they might be having. And so, you know, they don't have to worry that, you know, they need to parse out exactly what it is that they're freezing. We only want folks to, we're saying that this focuses only on the underlying agreement itself. We, you know, define this term standstill issues to capture that concept, and we refer back to that, you know, or we use it rather, for a variety of reasons, and make clear, you know, that this agreement doesn't address anything else besides those standstill issues.
And even as we use the term standstill issues, limiting it to those we find under the underlying agreement, we chose not to bring to this drafting the degree of specificity that we might see, for instance, in a heavily lawyered forbearance agreement, where, you know, the analogous term for what we call standstill issues would be those defaults that were known to exist, discussed among the parties, and were specifically the basis on which forbearance was being granted. In part, our thinking was, again, given the target audience, which is, you know, frankly more consumed and attentive to running its business than lawyering its business. You know, if you're in a payment default, you may very well find that for similar reasons you're in a covenant default, and we didn't want someone to use too fine a brush and miss something that was essential to be included among standstill issues. Term and termination. So this was simply this notion that we're just calling what I'm referring to colloquially as a brief timeout. One of the things we come to think maybe 30 days, 60 days, 90 days, you know, who knows? I guess, you know, in candor, when we drafted this and first published it, we probably thought that we would know that much more, that much sooner than we now think in our heart of hearts. But nonetheless, the idea is that this is a relatively short and temporary thing. And in the annotated form of the agreement, we go on to point out that, of course, and this is obvious to all of you, if things change and people decide to extend this further, they can do that. If they want to, sort of fold their timeout tent, as it were, at the end of the stipulated term, they can do that. And if they mutually agree to cut it short, they can do that. Just again, a starting point to sort of to work in good faith, subject to lengthening or shortening.
One of the things that we wrestled with was whether to leave it, sort of opaque as to how long a period to define, or instead to trigger it to or key it to some event, like an all clear event, or an all clear statement from the CDC or from the president or something like that. And the more we thought about it, the more we realized that it would be virtually impossible to define that in any way that was going to be accessible to the kinds of folks that we're hoping to reach. And of course, as we see, like, who knows what's opened up, who knows what opening up even means. And so instead we say, like, choose a day, choose a number of days, choose a date, and that will be the period, full stop, with the explicit instruction that if you want to end it sooner, you can end it sooner. And if you want to renew it, sign up for another 60 days, that's fine too.
Yeah, and we also thought that it's not necessarily over the moment the government, whatever that means, sounds the all clear, whatever that means. It's quite likely there's going to be a little bit of a ramp up time as businesses regain the ability to perform their previously contracted obligations.
I think the sort of heart of the standstill agreement, the operative terms, appear in terms 3 and 4. And term 3 is the provision where the creditor commits to standstill, not do anything precipitous, and is given the benefit of a tolling agreement, meaning that whatever, statute of limitations or other period of time, would otherwise occur will not be deemed legally to have occurred during the standstill. So we have the creditor saying, the creditor, again, being the person to whom performance is owed, creditor agreeing that despite the breach, despite the failure to perform, the creditor won't take any legal action against the debtor, but sort of recognizing that this, any applicable statute of limitation or other salient period is told for that standstill period, that number of days defined in term 2. One of the things that we were concerned about is that, we live in a world where creditors trade out of their claims all the time, right? Claims trading is a big thing. And, it's not hard to imagine that some creditors under these standstill agreements might say, well, I'd rather, sell my claim to somebody else. And given that we're trying to preserve relationships and keep this fairly simple, we wanted the creditor to agree that it would not transfer either its rights under the underlying agreement or under the standstill, but precisely because we don't want a debtor to find out that they've got a standstill agreement with somebody, but the claim or the obligation under the underlying agreement is now held by somebody else who is not bound by the standstill. And so we wanted to make that clear. One of the things we should have noted earlier is that in the definition of legal action, we try to be as broad as possible. So we obviously are contemplating things like going to court or administrative action, but also self-help, right? So the creditor that has agreed to standstill under term 3 is agreeing not to exercise self-help rights under Article 9 of the UCC or that might otherwise be available, just as they're agreeing not to commence a litigation. Anything else on the standstill?
No, I think I'm inclined to roll along to clause 4, paragraph 4, debtors, non-ordinary course acts or omissions. And so this is, I might summarily reduce to debtor won't make it worse for creditor during the forbearance period, right? So this is this notion that the debtor will refrain from engaging in any non-ordinary course transactions. You're supposed to be standing still, right? Not strategically and self-interestedly changing things while someone is meeting you in good faith. So you'll have prohibitions in our language on transfer of property or grant of consensual liens and security interests and things like that. And then in a very generic way, we tried to invoke an agreement not to engage in any transaction that results in a change of control. Now, most on this call have looked at change of control provisions that go on for paragraphs, if not pages, right? And you talk about, remote parents up the chain and this and that and the other. And there's a lot of things one can put here. Once again, we did not intend that this document would be the most comprehensive, which I suppose could also be phrased as the most daunting. We wanted this to be a document that was facilitative of people who needed something that was easy to work with, something that would start conversations, start thought processes. So this is an instance where, in my mind, we've been very sort of generic in an attempt to be both accessible and inclusive in prohibiting various changes of control and so forth. So here you see really the heart of the sort of bilateral nature of the standstill in paragraph 3, which Jonathan just summarized, and in paragraph 4, which I've just spoken to. Jonathan?
Yeah, and one of the other things that, we do here is we have the debtor agreeing not, to take affirmative legal action against the creditor during the standstill period. For example, seeking a declaratory judgment that, there is no breach because there's force majeure defense or what have you. So, the idea is mutuality, fairly balanced, keep the parties relatively calm, but we don't want businesses to stop doing whatever it is they're supposed to be doing in their ordinary course. Because obviously the whole point is that if you can, sell things and make money, you should do that, as long as it's not, sort of beyond what the parties reasonably expect. So we're trying to, thread this needle in a way that's, not especially sophisticated, but we hope is good enough for the sort of average, smaller, medium-sized business person who intuits what this is trying to get at. Term 5 is asking the parties to at least think about engaging in good faith negotiations and collaboration. And what this says specifically is that the parties agree that during the standstill period, they'll engage in negotiations in good faith to resolve their standstill issues, and they will support one another's efforts to obtain new financing or other relief that may facilitate performance under the underlying agreement. And when we drafted this, the intuition was that Congress was probably going to do something that looked like the CARES Act. It was probably going to do something that looked like the Payment Protection Program. We didn't know, exactly what it would be, but it occurred to us that any kind of new liquidity that might be made available to the debtor in particular might be inaccessible if the debtor is in default with a pre-existing creditor, namely the creditor under the underlying agreement. And so not only do we want the standstill to make it clear that, there's no active effort to enforce, but we want to encourage, can't require, but we want to encourage the creditor to work with the debtor in the debtor's efforts to, for example, take a Paycheck Protection Program loan if they can do so. As you'll see in a few minutes when we talk about breach and so on, we don't expect this is likely to be enforceable by a court. But again, in sort of consistent with this idea that this has both behavioral and legal goals, we hope that it gets people to think seriously about whether they can negotiate and whether they can help one another try to get out of whatever situations they're in. Other thoughts on that, Norm?
No, just to, as we were drafting this, we really hadn't seen, some of the relief packages that have come forth from Congress. And in the time since, I think many of us who've read them are even more confused as to what they mean, particularly if we compare them against the guidance that's come out in the time since. Some of you may have encountered this professionally or anecdotally, but there is some concern as to, in fact, what the eligibility criteria are and there seems to be some confusion as to that. And lest I be misunderstood, I don't mean to suggest that one can draft with great precision in a tremendously compressed time period. I do recognize that there were a lot of exigencies that Congress faced. But as you look at the black letter and the guidance and what have you, you could come to the conclusion that some things look a little different today than they did when the ink was first drying a couple of weeks ago. So we thought it best to keep this aspirational and general, that folks would recognize perhaps, again, that behavioral component, that it may be in their mutual, their shared best interest to play nice, cooperate, and see if there's a way to enhance liquidity or the ability to perform.
And in the time since, we did this and CARES happened, those of you who followed bankruptcy, corporate reorganization under Chapter 11, may know that there's this really significant dispute as to whether debtors that are in Chapter 11 can borrow under the PPP program. Some courts have said that they can and have ordered either the SBA or the applicable lenders to make loans to which the debtors would otherwise qualify. Others have read the regs or the underwriting criteria to say that, in fact, those borrowers can't borrow under the PPP facility or the PPP facilities, which at some level strikes me as problematic, but also yet another good reason to stay out of court, including bankruptcy court. So although we didn't think that was going to be a reason for using this, it's probably turned out to be one, yet another one.
Fair enough.
Norm, you want to talk about interim consideration? Or?
Sure. So we again, starting from the premise that there may be a valuable commercial relationship here, and elements may be susceptible of ongoing performance. So we here have from each side, right? During the standstill period, the debtor agrees to provide to the creditor, and then we have one of those sort of key here boxes for completion. Will there be partial payments? Will there be delivery of, a half a load of widgets every period or whatever it might be? So that's something we wanted to build in so that people could, again, for this short term that we contemplate for the standstill agreement, they could nonetheless recognize and focus on the fact that they anticipate partial performance on each side. Again, without prejudice to what happens ultimately, but at least to sort of keep things going between them. And then we have the reciprocal agreement that the creditor agrees to provide to the debtor, and then we fill in whatever it was. So they truly are structured as reciprocals where we can specify performance by each party to the other during the standstill period, if that's appropriate.
And one of the things we make clear in the annotation is, like, if the answer is none, because you just can't do anything, that's fine too. This is, Norm's exactly right. This is aspirational. And we don't expect, parties to sort of make this the substitute agreement. So if they can, do a little bit during the standstill period, that's great. And we want to, kind of focus them on thinking about doing whatever they can do. But we don't want to make it, too difficult, and we don't want to make it dangerous for them to do so either. So term 7 is breach, right? And we try to keep it super simple. Any violation by paragraph 3, that's the standstill, shall be called a creditor breach. And, that's where, by imperative reasoning, any violation of paragraph 4, that's where the debtor agrees not to, do anything out of the ordinary course or sue the creditor, will be a debtor breach. And again, one could easily imagine that, with lawyers like you guys, this could be a much more elaborate document, a much more elaborate set of statements. And we thought about, whether there's benefit to our audience in that level of elaboration, and concluded that there probably isn't, given our goals. That's not likely to be especially useful.
So remedies, of course, any contract has to have a remedy provision, generally following its breach provision. And so here we wanted to just sort of, take some steps to assure that people would not have an incentive or indeed a reward to the sort of behavior that we're hoping can be avoided here. So in the event of a debtor breach, the creditor can pursue any legal action, right? So if the debtor starts doing all those non-ordinary course things he's not supposed to do, like, hey, that wasn't the deal. Well, okay, now there is no deal. Similarly, in the event of a creditor breach, the creditor forfeits the rights that have accrued during the standstill period, but for this agreement. So that is to say, we wanted to take pains to be clear that if there's a creditor breach, the creditor is not suddenly in a position to improve its standing by saying, yeah, I've unilaterally changed my mind and now I get all the goodies that I gave up on the day that we signed this thing. You don't get those goodies. You give them up. That's basically the remedy. John, you can probably say that in a much more lucid manner than I just did.
No, goodies is great. I think that's right. So one of the key things that we try to focus people on is the fact that although the ability to enforce rights is frozen, existing rights as of the moment before the agreement will continue to accrue. So for example, interest would continue to accrue under a loan agreement, even though there is a standstill and therefore no ability to enforce a default under it. And so one of the things we point out in the annotation is that if there was default interest accruing prior to entering into the standstill, that default interest will continue to accrue during the standstill period. Conversely, if there wasn't a default declared such that a default rate of interest would accrue, then that's not going to start during the standstill period. In either case, the bite that we try to put into this for the creditor is if you renege, if you sue when you said you wouldn't sue, you lose whatever those rights were that would have accrued, those benefits that would have accrued during the standstill period. And most plausibly, those would be things like interest or penalties. You give those things up. And neither sort of remedy is terribly powerful. But again, we're not envisioning that this is going to last long, or is really meant to be. It's not meant to be a club so much as a sort of an aid to help people march through this in a collaborative way, if possible. Norm, you want to talk about reps and warrants?
Yeah, sure. So how does one skinny this down for a utilization such as this one? I think you really boil it down, as we've tried, to its essence. And so you have reps by each party that it has the power and authority to enter into this agreement, and that this will be a binding obligation. And, we, depending upon where we've spent our practice, we may have seen folks who, sit up a little straighter in their chair whenever they see anything following words like represents and warrants, and others who just say, yeah, we're down to the boilerplate, let's not worry about that. Our hope is that this, and I want to follow up on this a little later when we talk about signature blocks and the way we've set those up, but part of our thinking is that this will just slow people down a little bit. Again, we envision that many's the time this may be used without benefit of legal counsel. And just think about it. Gee, power and authority. Well, this is a corporation. Maybe I should convene the board of directors around my kitchen table on Saturday and get them to approve what I'm about to do. Or this is a limited liability company, and although my spouse and I are the two members, we made so-and-so our manager. So we might just slow people down a little bit to think about some of the formalities that might otherwise escape their thinking as they proceed. Jonathan?
Yeah, I think that's right. I mean, we kicked around the idea of not including reps and warrants at all because, really, who cares? For a 60-day or 90-day standstill. On the one hand, on the other hand, right? I mean, I'm just getting my workshop students asset purchase agreements in, which have 14 pages of representations and warranties, which no one really wants to read, but of course lawyers get paid to spend time thinking about. And so I think the compromise position is, we want, consistent with our behavioral goal to get people to take this seriously and to think about what they're doing and hopefully do it, more effectively. But we didn't think there was much benefit to really going through the elaborate types of reps and warrants that you would ordinarily see in any sophisticated agreement, including, a standstill agreement that, any medium or large law firm would undoubtedly draft. Term 10, we want to make this really easy for folks to do. So, as we said before, there's an electronic version available on the Business Law Today website. And, because we live in a world where things like, the Uniform Electronic Transactions Act and e-sign, make it possible to sign electronically. We wanted to make it clear to the parties that that is in fact something they could do. I think it would be true even if we didn't say this, but again, right, consistent with a signaling goal, we wanted to, get the folks to, both focus on the fact that they could do this quickly and easily, ideally thoughtfully and quickly and easily, but also that there's no problem with them doing so electronically.
And in term 11, notices, this is a place where we got very practical. Perhaps like a lot of us, I haven't been in my office in Wilmington in about 7 weeks. I haven't taken a phone call in my office in Wilmington in about 7 weeks. Happily, we do have a skeleton crew in our mailroom that comes in and scans the first page of every piece of correspondence so that we can monitor and request the rest of those pages if we need them, or indeed, by the governor's grace, go to the office to deal with anything of an emergent nature. But we came to realize that a lot of the folks who may be utilizing this form likewise may not be at the places they had anticipated being for the duration of the underlying agreement. They may not be in their place of business. They may not have access to their business phone, their business fax, what have you. And so this term simply is a mechanism by which people can say, oh yeah, I'm not going to be there for a while. So here's the number, here's the address, what have you, where you can reach me and send me notices under this standstill agreement. No more, no less.
Yeah, and again, it's consistent with this idea that this is not replacing the underlying agreement. It's, sort of a supplement to it while we're trying to figure out what the heck is going on.
Yeah, exactly.
So, and then this is the signature block, and there's just a couple of things that we are hoping to draw folks' attention to. Obviously, you can, we anticipate that this is, probably going to be executed by some kind of entity. So, the name of the entity would be the first thing that one keys in. The type of entity is the second, and then, the name of the human being that's executing it below the byline. And, you have it for both parties here. We obviously could have, asked folks to be much more specific about the sorts of things that they're saying about their identities for this purpose. But again, consistent with this idea that most folks we're thinking about probably don't know or aren't going to, it isn't going to matter to them a great deal to engage in that, level of refinement. We wanted to be fairly straightforward on it.
Yeah, but again, just the idea of slow down, a little bit of signaling, and an opportunity for people to focus. I remember very early in my career, I was doing some lending work for a local lender, and there was a contract that ended up subject of litigation, and it introduced the party as Joe Smith, and then he signed Joe Smith, comma, president. Well, which is it? So hopefully we can help people to achieve a little greater clarity and consistency than I saw back on that day in 1989. So, Jonathan, you have any words of wisdom to bring us home?
I mean, nothing too much. I think that, this is just a little passage from the article that we published on Business Law Today. We think that obviously there are many very important things that people can be doing right now to deal with the COVID crisis, but for most of us, I think commercial litigation is not likely to be one of those things. Our instinct is that working things out is probably going to be a more effective thing in the near term and in the long term, if it's at all possible. And so, although we don't think it's really possible to save the global economy with a form agreement, that is in a sense, what we're trying to do, even though, as my wife says, this sounds like the most boring thing you've ever worked on, because.
And that's saying something.
And that's saying something, but it's like, I mean, who gets excited about a form contract on a model, an ABA website? And yeah, I mean, we actually have two bits of homework for you guys. One obviously is to give us any feedback that you have, if you want to do so. Now that's great. If you want to shoot us emails, that's great. This may not be the last iteration of this thing. And number two, if you think that this might be of use to folks that presumably people who are not your clients, but maybe folks that your clients know, not-for-profits that, whatever, are not in a position to realistically hire counsel to do this for them. Please feel free to share the link with them, share the underlying materials. We can send you guys a PDF of the slides if you'd like. But we are trying to get the word out. We've had some success at doing that. But we think that, probably more folks who at least think about this stuff, go through this process are, is better rather than fewer. Other thoughts, Norm?
No, I think that's really it. A large part, was just sort of emphasizing a way of thinking about this that may be counterintuitive to people who want to reach for their sword and, avenge their rights, but that may not actually be the best thing. So slow down, think, and hopefully do what is ultimately preferable.
That's great. Thank you, Jonathan, Norm. That was really informative. And if you guys have a few more minutes, maybe we can open it up for any questions that folks have. Jonathan, you'll see I tapped into the chat box a few questions I had, but let other folks sort of jump in.
This is Carl Schneider. I tapped in a little late. I apologize. I was thinking this is very well thought out and really, I mean, it touches a lot of issues and it's a very valuable work product. I was thinking what I would do with what I would ask for if I were the party representing the party least likely to be in default, like the lender, the lender debtor. I think if I would be able, rather than have a term to a number of days or a date or an event, I think it might be appealing to say this agreement will last until either party gives 10 days notice or so amount of notice that we want to opt out of it. I think that just gives a little more control if things are going in the way that nobody expected, or at least one of these parties expected. It's just a little more flexibility, and if everything's status quo, you don't give notice. If it really goes a little haywire, you can get out of it by giving notice in some period to turn around. The other thing I was thinking about, if I had the most leverage, I might want to bargain for some kind of access to information or getting reports or something from the debtor periodically, like a monthly statement or the right to inspect something, just some way to know what's happening in the business while I'm tying my hands up. Two passing thoughts.
Thank you. Those are great thoughts. Thank you so much.
Those are great.
This is Fred. I have one quick question. Maybe I missed it in the press. By the way, it was excellent. Thank you very much. I think I may have seen it. It actually popped up somewhere where I was looking. So thank you. I'd seen it on one of the websites, and it's very straightforward. I don't remember it saying, maybe it doesn't need to, maybe it's implied that neither party is waiving or giving up any of its claims or defenses by entering into this agreement. Do you think that's implied by the agreement? I mean, I wasn't bothered by it, but I was wondering if it's one additional thing that we may put into agreements like this.
So that's a great question. Let me start. Let me go back to the first comment about that's okay. Well, I'll start at the first one, which is on the more flexibility in the termination or ending of the term. I mean, especially as it seems that the uncertainty that has been bothering us is going to get longer, not shorter, right? I think we really might need to think about, giving people that flexibility. And if we do another version of it, we might well make a note of that, or think about a way to tweak the language so that folks can either choose a date certain or a number of days certain, or, you can terminate it on a certain number of days notice. The number of days presumably being enough for folks to, line up the artillery or do whatever it is that they need to do to, protect themselves now that the truce is off. On the monitoring point, that's a really good point. And I have to confess, I didn't think about it very much at all, precisely because I didn't think that things would last that long. But, again, if things remain this uncertain for, a significant period of time, for version 1.1, it might be worth thinking about including something on monitoring. And then the no waiver stuff we did think about, and, it's a great question, Fred, as to whether it's implicit or not. My instinct was it's lawyer talk, and it probably, it won't help the parties very much to read it because they're not really going to know what it's about. If anything, again, if, my behavioral theory is right, it might incite them to want to haggle more than we want them to haggle. It might remind them of their grievances, that we don't, maybe we don't want to do that. But
good point. And they may start asking each other, well, what are you waiving? And they start getting, they start putting their litigation hats on, and already they're starting to. So. Yeah,
but if we do another version of it, in the annotation, right, it might be worth saying, by the way, we don't have one of those no waiver things here. Mm-hmm. And we don't have any idea what that means. We suspect it's implicit that no party's waiving anything because they're freezing their rights. But, that is something that folks, in these things do think about sometimes, if they're being being more elaborate about it than we are. Norm, do you have
was sort of a question I had to you that was sort of implicit in the scope of the standstill. I mean, a lot of the times there's internal, sort of contractual time periods within the contract, especially events of default, times to cure, all that kind of stuff. And I guess that standstill would cover stuff like that. It's not as explicit because it's really more focused on statute of limitations, things like that. But, I don't know whether that is an issue or not.
So I wanted to give you a comment from the perspective of somebody who's practiced for over 40 years, mostly in debtor-creditor work. First, I want to tell you it's terrific what you've done, and I understand the general framework of trying to get people to talk to each other without having guns at their heads on either side. And I think you accomplished that. But the one thing that struck me as unusual, or maybe non-productive, or whatever you want to call it, is the creditor's inability to sell the account. I think if I were representing, and I'm not representing, obviously, anybody in your scenario, but if I were representing a creditor, I wouldn't sign that. I would prefer to have something that says, we're not going to sell this, but if we do, we're going to notify the buyer and they will be bound. Because from a creditor's point of view, when the cash flow is the worst that it's been forever, you don't want to put handcuffs on the creditor's ability to stay afloat. We didn't even talk about, you didn't talk about, and it probably doesn't contemplate existing factoring agreements. But there are lots of companies who need to factor their receivables. And I don't know what the market looks like today and how it's been affected, I can imagine. But it obviously is impacted by an agreement like this. So while I understand you want people talking to each other, not shouting at each other, I think the flexibility of allowing this sale to take place with prior notice to the other side and to the buyer would be fair.
Yeah, that's a really good point. And again, I was maybe too optimistic in thinking that, it wouldn't be necessary to have that sort of mechanism because, like it'll be over soon enough. But, that's a fair point. Like, maybe we want to give people the optionality to, to assign out, provided that the buyer remains, subject to the same constraints that the original creditor was subject to.
There's no harm, no foul if the person who's buying the account is bound by this and knows about it.
Yeah,
From my
that's a really good point.
Except the loss of the relationship, which is at that point probably far gone.
Right.
Thank you, Lee. I'm reminded how we're all constrained to see the things that we're accustomed to seeing and less likely to see those that our brothers at the bar have seen for many, many years. Thank you so much for that perspective.
Yeah, that's a good point. And to John Broder's observation or question about stopping the running of the clock under the operative underlying agreement, I think my instinct is that, stopping time means stopping time. And so if, at the moment you execute this standstill agreement, there was still 5 days left to cure before an event of default could actually be declared under the underlying agreement. This agreement comes to an end for whatever reason, then there's, the clock starts to run again. And so the 5 days, counts, but you have to, pick up and let whatever other, period of time had to have run out.
Not to say that couldn't have been made more explicit, but I share Jonathan's view on that. Yeah.
Great. And I think the other question I had, and I know you had it in here, but do you think as a legal matter that this kind of agreement requires additional consideration to be binding?
I mean, that is the sort of classic, restatement second 207 problem. And I mean, my view is no. I mean, people are giving things up, right?
Yeah,
that's a kind of consideration, and they're doing so mutually. So I think that is the consideration.
Yeah, I think that's right. Consideration is required, but that suffices.
Yeah, I think that's true.
And it's mutual. I mean, the classic problem under, under a release, I can't remember what the hypothetical in the restatement is, if you just agree to forbear, but there's no mutual consideration, then it's not enforceable. And that's true, right? The creditor alone forbears, and the debtor and doesn't get anything. I'm sorry, doesn't give anything to the debtor. If it's not mutual, then it is a problem. But we think that the mutuality of this should get around that. In any case, nobody's going to be litigating consideration.
Right.
But it's a good question. We did think about it.
Any other questions that folks had or observations?
Yeah, I'm curious if you've received any feedback on which industries this might be most useful in, or if you have predictions about where people might most want to hear about this option.
I have not. Jonathan, have you? I mean, we talked about the size of the businesses and that sort of thing, but in terms of industries?
Yeah, no, that's a great question, David. And one of the things we've asked the ABA for is data on who's using it. And of course, as we like to say, the American Bar Association has the best technology available in 1995, which therefore means that while they can tell us what the number of hits was, it's improbable that they'll be able to tell us too much about the characteristics of those who are looking at it. But it's a great question, and I'll at minimum I'll ask the folks at the ABA to see if they can somehow by I don't know virtue of what figure out something about the characteristics of those who are looking at it. Because I don't actually have I mean, the one thing that I think would be true for most folks who use it is that they don't have lawyers,
right?
Or they don't they don't have the resources to pay counsel for this. But that's a large and growing number of people.
Yeah.
Did you have your hand up, Jonathan?
Yes, thank you. I just had a quick question. First of all, thank you very much for this presentation. I actually had Professor Lipson in the spring of 2007 when you taught at the University of Pennsylvania commercial credit.
Oh, God.
Great class. Thank you very much. Very quick question. So I'm a patent attorney at a patent law firm. We don't have any other commercial department. We have IP, so it's trademark, copyright, patent. The closest we get to any type of contract work is we have a basic patent assignment that we've developed that we give to our clients. And we have very sophisticated clients, Fortune 500, but also down to individual inventors. So, you know, the Fortune 500, they can figure out these standstill issues themselves. If we were to give this agreement or suggest this agreement to a small company, an individual inventor who's in a problem, what kind of professional liability are we opening up ourselves to when we don't practice commercial law?
Jonathan, let me start off on that one because that was close to what you and I talked about when we put this presentation and, for that matter, the article and the form together. Yeah, I think you raise an excellent question. And as always, the question of whether one has created an attorney-client relationship turns largely in most jurisdictions on the reasonable expectations of the putative client, not the expectations, the self-preservation instincts of the putative lawyer. So I think one wants to take pains to accompany any such recommendation or referral, if you will, by clear and memorialized explanations. I'm not telling you to use this. I'm not telling this fits you. In fact, I'm not counseling you with respect to this set of issues whatsoever. However, there's a Barnes and Noble down on the corner. They've got a section. By the way, this URL will take you to something that you may wish to consider as well. I think you want to make it very clear where the scope of the engagement you have, right? Because you're in your example, you already do have an attorney-client relationship with these folks, and what you're seeking to do is to delimit what you are representing them for and what it lies outside the scope of that representation. Yeah.
It's a really good question, and I think all you can do is disclaim and make it clear to the client that you appreciate that this is an issue for them, but this is something that you've encountered and you can't vouch for its effectiveness. You think it might be useful for them, but this is not within your area of expertise and not within the scope of your representation.
Right.
That's a great question.
Great. Thank you.
Well, I appreciate this, gentlemen. This was terrific. I think it was really, really useful, very practical. We've gotten it out actually to all. We have about 200 lawyers, give or take, in the lawyers group. So we've actually gotten a copy of the agreement out to everybody. We'll sort of reiterate if anybody's got any questions or suggestions to come back to you as well. And looks like you're off to a great start with this.
Great. Well, thank you so much, John, for inviting us to do this. This is great.
Thank you. Norm, when you get back in the office, please say hello to my good friend, Gene DiPrinzio.
Oh, I sure will.
Okay,
I sure will.
Yeah, our colleagues in a professional association. So
of course.
Gene there. He's a good guy.
Okay. Everybody be well and safe. Take care.
Thanks.
Take care. Yes, thank you. Be safe. Take care.
Bye-bye now. Thank you, everyone.
Bye-bye.